Welcome to meeting number 7 of the House of Commons Standing Committee on Justice and Human Rights, studying Bill C-7. First and foremost, I understand that Mr. Manley from the Green Party is requesting to join our meeting today. Mr. Clerk, is Mr. Manley with us right now?
He's actually requesting to be admitted, which I will grant the access right now. Thank you.
Thank you. So I seek unanimous consent from the committee to allow him to be part of this committee, if that's okay. A thumbs up to show your consent, please. Yes, go ahead, Mr. Clerk,
yes,
to allow him in. Thank you. So to ensure an orderly meeting, I'd like to outline the following rules. Members and witnesses may speak in their official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen to select either the floor language, the English language, or the French language for your own interpretation needs. A reminder that all comments by members and witnesses should be addressed through the chair. When speaking, please wait until I recognize you. Unmute yourself and speak slowly and clearly for interpretation's sake. When you're not speaking, your microphone should be on mute. With regard to the speaking list, Mr. Clerk and I will do our best to maintain a consolidated order of speaking for all members. And I have time cards. I have a 1-minute card and a 30-second card to give you advance notice for how much time you have remaining for your remarks and for your questions. Now, Mr. Manley has also asked if he can be allowed some time to also ask questions. So I ask unanimous consent of the committee to allow Mr. Manley 2.5 minutes for the first panel, 2.5 minutes for the second panel to ask his questions. You can do this by showing me a thumbs up or a thumbs down if you don't agree. Okay, we do not have unanimous consent. So please note that members are able to share their time with Mr. Manley if they should choose to do so. But Mr. Manley is welcome to visit and to participate in the committee. At this time, I'd like to welcome our witnesses. We have before us, appearing as an individual, Dr. Jennifer Gibson, who is the Director and Sun Life Financial Chair in Bioethics, University of Toronto, Joint Center for Bioethics. We also have Dr. Elaine Nod, family physician and clinical professor in the Department of Family and Emergency Medicine at Laval University. We also have the Honorable Andre Rochon, who is retired Justice of the Quebec Court of Appeal, and we have the Canadian Bar Association. Each witness will have 5 minutes to make their opening remarks. We'll go ahead and start with Dr. Jennifer Gibson. Please go ahead, Doctor. You have 5 minutes.
Madam Chair, I'm sorry. Just before we commence, I just find it a bit less than parliamentary that we're allowing Mr. Manley to participate, but not allowing him to ask questions for 2.5 minutes in each of the next 2 hours. And I'd actually ask for a recorded vote on that point. Thank you.
Madam Chair,
go ahead, Mr. Moore.
I would give my consent for 2.5 minutes for each panel, but not, I thought you had said 2.5 minutes per round, which would be 5 minutes.
No, sir. I had said 2.5 minutes per hour. So for the first panel, 2.5 minutes, and 2.5 minutes for the second panel.
That's fine by me.
Is that, can I ask again for unanimous consent for 2.5 minutes for Mr. Manley? Can I see your thumbs up for everybody? Okay, just to confirm, I see thumbs up from every single member that is permanent on this committee. Thank you, Mr. Virani, for raising that. Greatly appreciated. And I will add Mr. Manley to the speaking list at the bottom of each of the hour. Thank you for that, Mr. Virani. With that, Dr. Gibson, please go ahead. You have 5 minutes.
Madame la Présidente, pour éviter de...
Madam Chair, I don't want to have to interrupt our witnesses. I think it would be good if you could remind the witnesses that even if they have very little time to make their presentation, but we would ask that they speak slowly and distinctly so that interpreters can do their work well.
See, Monsieur Thériault, I
Thank you, Mr. Thériault.
made that remark when I had opened, and I remind the witnesses again to please speak slowly and clearly so that the interpretation can do its work. Thank you. Go ahead, Ms. Gibson. Dr. Gibson, you have 5 minutes. We can't hear you, Dr. Gibson.
Oh, about now.
There we go. Yes,
there we
perfect.
go. Thank you so much. Thank you so much for the invitation to join you today. As noted, I'm affiliated with the University of Toronto, but in 2015, I co-chaired the Provincial Territorial Expert Advisor Group on Physician-Assisted Dying. And in 2017-18, I was co-chair of the Council of Canadian Academies Expert Panel on Medical Assistance in Dying and chaired the Working Group on Advance Requests for MAID. Today, I'm speaking as an individual, drawing from these experiences and my disciplinary background in ethics and health policy. I had the privilege to meet with this committee in spring 2016 in relation to Bill C-14. Over the last few weeks, I've been reflecting on how much has changed in 4.5 years and how better prepared we are to contemplate amendments to the legislative framework for MAID in Canada with some confidence. In 2016, we did not have any Canadian experience to draw from and relied on experience from other jurisdictions. We did not yet have systems and care processes in place to offer MAID to eligible persons and needed to build these. And we did not know what actual effect the introduction of MAID would have on Canadians. Would it displace palliative care? Would it make people more vulnerable, not less? Today, with the benefit of almost 5 years' experience, we have learned that MAID can be provided safely and compassionately to Canadians. We have Canadian evidence to draw from. We have the lived experience of Canadian families, caregivers, and clinicians to shed light on its practice. And we have heard from community groups and individual citizens about how and to what extent MAID fits within a continuum of supports for persons who are suffering. Bill C-14 sought to outline a legislative framework, including eligibility criteria and procedural safeguards, that sought ultimately, to the greatest extent possible, to respond to Canadian suffering whilst balancing the autonomy of persons seeking MAID on the one hand and the interests of vulnerable persons in need of protection and those of society on the other. The project of striking the right balance of these values-based commitments continues today. Many of the comments from witnesses and organizations who have appeared before this committee have drawn attention to the suitability and appropriateness of key safeguards, both those which are in the current legislative framework and those which are being contemplated in Bill C-7. Such current safeguards, such as the 10-day reflection period and the requirement of final consent, were introduced in order to ensure that only those Canadians who wished MAID actually received it, and to protect and promote their autonomy. Experience of the last 4.5 years has shown that the effect of this safeguard may not have been what was originally intended. On the one hand, we have heard from clinicians about some patients who have foregone pain medication and endured preventable suffering in order to sustain their capacity to provide final consent. On the other hand, we have also learned from clinicians, families, and caregivers that persons seeking MAID are most often not ambivalent about their choice. Or, in the words of a member of the public who emailed me in December 2015, who was facing a life-limiting illness, commented to me, "No patient is going to reach such a decision and request lightly." Hence, the removal of the 10 clear days and final consent seemed to be a good step forward towards striking a new appropriate balance in safeguarding Canadians who have already been found eligible for MAID. There is little doubt about the importance of safeguards to protect vulnerable persons who might, as per the original preamble to Bill C-14, be induced in moments of weakness to end their lives. A lesson we may draw from our experience of the last 4.5 years is that, in developing safeguards, we must be especially attentive to the potential impact of the safeguards, notwithstanding their intent to protect. We must be especially wary of a safeguard if it may reasonably have the effect of rendering some persons more vulnerable. The protection of vulnerable persons turns on safeguarding competence, voluntariness, and consent. Exclusion of otherwise competent persons may be justifiable in limited circumstances if there is a strong case to be made from the perspective of justice. Failing this, though, these exclusions violate the autonomy of competent persons of such groups and unjustly force these individuals to remain in a state of enduring and intolerable suffering. For these reasons, we may wish to consider whether the 90-day reflection period will, in fact, be protective or may instead contribute toward enduring suffering of persons who are already found to be eligible for medical assistance in dying.
Thank you, Ms. Gibson. I'm going to have to stop you there. We are at the 5-minute mark, and I'm hoping that the rest of your testimony can come out in questions.
Oh, absolutely. Thank you.
Thank you very much, Dr. Gibson. We'll now move on to Dr. Elaine Nod. Sir, you have 5 minutes. Go ahead.
Thank you very much, Madam Chair. I first want to thank the committee for the invitation to share my experience. I've been a family physician and provided palliative care for 35 years. I have taught at Laval University in clinical medicine. I also appeared as a medical witness in the Gladue-Truchon case in February 2019. And I have personal experience in supporting patients and their family members and dozens of caregivers as well. I've also attended many conferences, and therefore I have a lot of experience in this area. This is actually a type of compassionate care, and it is never an impulsive decision to seek MAID. It is based in suffering, and we have to have actually met with patients and accompanied them to be fully aware of this. There is no opposition between palliative care and MAID because the two support each other mutually. In all of our palliative care centers, MAID is integrated. It is a possible choice. Over the past 5 years in Quebec, we have been able to apply MAID and respect patients' rights. Sometimes there have been institutions and physicians that have intervened, and this is where patients' rights have not been protected. 33% of the requests have been rejected one way or another or not dealt with. There are major needs of patients that can interfere with their rights. First of all, the need to have an independent assessors, also the impossibility of having an advance directive. There are good things that have been changed in Bill C-7. There are things that need to be changed. First of all, the criteria of a reasonably foreseeable death has been declared unconstitutional by the Superior Court of Quebec. It doesn't match any medical decision. It doesn't appear in any medical manual, and it has not been used in Quebec. If we eliminate the reasonable foreseeable death as a criterion, then it should just be, it can't be used as a safeguard because that doesn't make sense. We need to really base the need on the patient situation. So that term should not be used because we already have safeguards in place to help patients. If the legislator wants to have different safeguards, then the term of prognosis of less or more than 12 months could perhaps be used as a replacement. This notion of a prognosis is very clear and is used every day in medical practice. I have more comments in my submission, but we need to allow patients to see the light at the end of the tunnel. The term assisted suicide should also be changed. We should use instead MAID through oral means or oral MAID. And then there is the issue of advance directives, which are not covered. There should be 5 criteria in order for people to be eligible for MAID in those circumstances. The bill should include much more explicit and rigorous criteria for refusals or cases where MAID is not administered, because that's where the obstruction actually takes place and where patients' rights are not protected. We have seen this in Quebec. As I mentioned, there is a summary of my recommendations on the last page of my submission. Thank you, Madam Chair.
Dr. Nod, for staying within those 5 minutes on the dot. We'll now turn to the Honorable André Rochon for 5 minutes. Go ahead, sir.
Ladies and gentlemen, I want to thank you for inviting me to speak to you and giving me this opportunity to speak about advanced directives for MAID. There is a strong consensus in the country to protect the autonomy of people, and I think we should immediately amend the bill that you have before you to enable anyone with Alzheimer's disease or another major neurocognitive disease the ability to have access to MAID. I would just remind you of why we are here at this point. We had the Carter decision that indicated that patients have a right to liberty and security, and they should be able to make their own decisions. In 2016, Bill C-14 was adopted. There was a panel of experts that studied 3 types of situations, including those with cognitive illnesses. Then we had the decision that led us to this bill, and it was indicated in the judgment that people in society, even those that have lost or would lose their capacity to decide, that they should have their right to MAID anyway, because they have a lot of distress and anxiety at the end of their life that needs to be addressed. Given this suffering, the issue is not whether compassion in Canadian society will allow these people to have access to MAID, but we need instead to define criteria to be able to protect people who are potentially vulnerable, but also to take into account the clearly expressed desires of these people. So if there is a diagnosis that is likely to lead to severe dementia, then there needs to be an ability on the part of those people to seek MAID and to give directives before their cognitive skills are severely impaired. People have access to health care. they need to be eligible for that health care, be at least 18 years of age, be able to freely express their desire without any outside influence. And finally, a doctor must attest that the person meets the criteria of being able to freely express their desires at the time that the directive is signed. To be valid, the directive must be renewed in writing after 6 months and make sure that the 4 criteria are still met. The directive is very important because it allows for time to reflect and to make sure that no impulsive decision is made. The directive can be canceled at any time in writing. The patient can request that the multidisciplinary team begin an initial assessment when the diagnosis is made and that there are reasonable reasons to believe that an advanced stage of the disease is going to be reached. So I've given you a model here of what would be a good type of directive. But the important thing is that anyone with such a diagnosis of dementia, such as Alzheimer's, has the right to meet criteria that would enable them to seek MAID. So we want the government to help us to allow patients to end their suffering and to be respected. Thank you.
Thank you very much, Monsieur Rochon, for staying within the 5 minutes. So now, last but not least, we will go to the Canadian Bar Association, represented by David Roberge. Please go ahead, sir. You have 5 minutes.
Good morning, Madam Chair and honorable members of the committee. My name is David Roberge, and I am a member of the Canadian Bar Association's End of Life Working Group. Thank you for inviting the CBA to discuss Bill C7 today. L'association.
The Canadian Bar Association represents over 36,000 legal counsel across the country. The CBA's main objectives are to improve law and the administration of justice. Our submission was prepared by the CBA's End of Life Working Group, which is made up of representatives from many types of expertise, including constitutional law, human rights law, health, criminal, succession law, the rights of seniors, children, and privacy rights.
To clarify the law about MAID following the Quebec Superior Court's decision in Truchon, we have some concerns with Bill C7. I'd like to use my opening remarks to outline some of them. Eligibility to MAID should be aligned with the criteria established by the Supreme Court of Canada in Carter, taking into account the protection of vulnerable people. The CBA supports the Quebec judgment in Truchon and highlights its interpretation of Carter, namely that the essence of the Supreme Court decision is not proximity of death, but rather the prevention of intolerable suffering, as well as dignity and autonomy of the person for those who are capable to clearly consent to the termination of their life. We also support a patient-centric approach for capacity and consent as adopted by the Quebec Court in Truchon. Returning to Bill C7, in our view, mental illness should not be excluded from the scope of the legislation, especially given the full MAID review initially planned for June 2020 and now pending. This exclusion forecloses a thorough review of the issue and suggests the conclusion that has not been debated or recommended. In Truchon, the court stated that vulnerability must be assessed from an individual perspective through informed consent. In our view, the general exclusion of all persons suffering from mental illness is likely to be constitutionally challenged. Bill C7 proposes two different sets of safeguards for MAID. the application of which depends on whether the person's natural death is reasonably foreseeable or not. The criterion of reasonably foreseeable death that was declared unconstitutional in Truchon has caused significant uncertainty in practice, and Bill C-7 does not give any guidance on how to apply it. So should the government maintain different sets of safeguards, we recommend that guidance be given to avoid confusion on which safeguards apply and to ensure appropriate access to MAID. On another topic, the CBA has reservations about the requirement that one of the two assessors must have specific expertise in the condition causing the person's suffering. Appointments with specialists can take several months, and in some communities are simply not available. There is currently no requirement that individuals seek specialists when applying for MAID. It is up to the practitioners to determine their own level of expertise when assessing informed consent and to make an appropriate referral if need be. While some situations could justify seeking the opinion of a practitioner with specific expertise, a blanket requirement could have a disproportionate impact on some individuals and create a significant barrier to MAID. Enfin, le projet de loi.
Finally, Bill C-7. Under Bill C-7, final consent for MAID can be waived only if death is reasonably foreseeable. In our opinion, waiving consent should be possible whether or not death is reasonably foreseeable, because it is possible to lose capacity consent in both situations.
On behalf of the CBA, thank you again for the opportunity to present today. I look forward to answering any questions you may have during today's session.
Thank you very much for that. Really appreciate it. We'll now go into our first round of questioning for 6 minutes, starting with Mr. Lewis. Go ahead, Mr. Lewis, you have 6 minutes.
So thank you very much, Madam Chair, and thank you to all the witnesses, of course, today. It's so vital that we continue to hear across the country and have these discussions and open dialogue, and we certainly could use a lot more of them. Dr. Catherine Frazee, renowned academic with a disability herself and leader of Vulnerable Persons Standard, presented on Tuesday to our committee. She asked the question, why us? Why not Indigenous or a suicidal healthy young man or other marginalized persons on their fringes? What is it about persons with disabilities that make it okay to target this character protected group for a special track to get suicidal completion and other groups get help and protection and resources? She went on to point out that a majority of the Canadian population wanting MAID for those living with disabilities don't mean that they should be put in danger and that their minority voice be silenced and ignored. In our last meeting, Liberal member Marcus Pawlowski, in his question to Dr. Ewan Gallagher, said that if his son suffered a spinal cord injury and felt he wanted to end his life, he would support his son. He said this to an able-bodied witness among 3 other witnesses who live with disabilities. I have to believe that this was interpreted by these brilliant women as an instance of ableism, and this is exactly the kind of discrimination that makes disabled Canadians fear for their lives when Parliament is considering a bill like C-7. It sends them a message that their lives are not worth living. The impact of allowing MAID, which is an extremely inexpensive and fast-tracked option in the absence of other options, such as financial support, pain specialists, good housing, well-trained and sufficient home care, will lead to coercion, as evident already by many witnesses on Tuesday, such as Roger Forley and Taylor Hyatt. Given a recent release in the Netherlands showing that there is a growing interest in euthanasia from vulnerable people, these less educated, poor, isolated, lonely, and the findings suggest that many of the people would not ask for euthanasia if good social measures were in place. My question for Dr. Nod, please, through you, Madam Chair, is what do you think about disability groups unanimously asking for protections and not a suicide completion track in Bill C-7?
Go ahead, Dr. Gibson. You're on mute.
My apologies, Madam Chair. I thought the question was directed to Dr. Nod, but
my apologies.
Yeah, so perhaps I'll just pause and clarify.
Go ahead, Mr. Lewis. Who are you addressing the question to?
Dr. Lod, please, Madam Chair.
Please go ahead, Dr. Lod.
Thank you, Madam Chair. I understand that the question is for me. Thank you very much. Well, often this is presented as a choice between MAID and resources for marginalized and vulnerable groups. It isn't a case of actually choosing between the two. We have to help marginalized groups, give them all the resources and supports that they need. But some ill people may be wanting to make the free and informed choice of seeking MAID because their life, in their opinion, no longer is worth being lived. It is very clear that the right to life should not be transformed into the requirement to remain living. So we need to reassess the capacity to consent, and the Truchon decision clearly indicated that it isn't a particular group that is evaluated as a whole, but rather a case-by-case patient-centered approach that is needed. So obviously we have already asked the question about people with disabilities. In the case of Mr. Truchon and Ms. Gladue, it is not a case of choosing between MAID and having resources. Both are needed. It depends on the individual's opinion of his or her situation, because only an individual can really assess whether the situation remains tolerable or not.
Thank you very much, Madam Chair. And through you again to Dr. Nod, please, one last question for you, sir. What do you think about the stories of coercion that we heard in committee and that are emerging in the news in light of the Netherlands study, which is farther along since implementation and already has evidence that this is a real issue? Thank you, Madam Chair.
Excusez-moi.
I'm sorry. Madam Chair, there was no translation for that, no interpretation for that question.
Mr. Clerk, if you can just confirm that interpretation is working properly.
It is now working, Madam Chair.
Okay, we'll just suspend while it is now working, or it's not working?
It is now working.
It is now working. Perfect. Thank you, Monsieur Thériault, for pointing that out. I have stopped the clock for you, Mr. Lewis. Don't worry about that. So now that interpretation is back on, Dr. Nod, you have 30 seconds to respond. Please go ahead.
Could I please have interpretation for the question? I just want to be sure I understand it well. Madam Chair, I would like the question to be repeated, and that was the point of my comment, because I don't want to just hear the answer.
Mr. Lewis, if you can please go ahead and repeat your question. Thank you.
Thank you, Madam Chair, and thanks for being so fair with this. It is a very important question. Again, to Dr. Nod, please, what do you think about the stories of coercion that we heard in committee and that are emerging in the news in light of the Netherlands study, which is farther along since implementation and already has evidence that this is a real issue? Thank you, Madam Chair.
For 30 seconds, Dr. Nod, go ahead.
Merci, Monsieur.
Thank you for that question. We have to be very careful when we cite studies from other countries because they have a different jurisdiction, they are different societies, and it is not because a study comes up with some finding that it is necessarily something that is conclusive. And over the past 5 years, it is not the application of MAID that has been a problem, but rather the hindrances and impediments that some providers and institutions have set in the path of patients. We have to deal with that.
Thank you very much, Dr. Nod. We'll now move on to the Liberal round of questions. I understand that Mr. Virani, you have the first minute, and then the remainder for Mr. Maloney. Please go ahead, Mr. Virani.
Thank you. It may be 90 seconds. I just want to say thank you to the witnesses. Thank you to Dr. Gibson, to whom I'll direct my questions. Thank you for your expertise on this issue over the past many years. I'm proud to call you a constituent, Dr. Gibson. The issue of autonomy has come up, and you underscored this in your own testimony. And what happened on Tuesday's meeting was questions were put about the autonomy of those who are persons with disability, and allegations of discrimination were put into the record as to the idea that by proposing a bill like Bill C7, discrimination is being perpetuated against persons with disabilities. I find it actually to be quite the converse, and so do Senator Petitclerc, and indeed a former Conservative cabinet minister who is himself a person with disability, Stephen Fletcher. Because in the Chouchon decision, they looked at this particular idea and said that, in fact, if you deny persons with disability the ability to make a decision autonomously about when they pass, you're in fact discriminating against them in contravention of the Charter. Given your expertise in bioethics and autonomy, could you comment on this aspect of the Chouchon decision and how it intersects with what we heard at committee on Tuesday? Thank you, Dr. Gibson.
Yes,
in 60 seconds, please. Thank you.
Okay, I'm happy to do so. I think there are a few things here. One is that to recognize that autonomy, we often think about it as an individual, but many of our decisions are made in thinking about the people around us. So it's a social conception of autonomy, which we all experience in our day-to-day lives. So I think there's reasonable concerns that there may be social influences around a voluntary choice. That said, one of the things that was most interesting coming out of the first annual report of MAID in Canada, which just came out fairly recently, it showed that of those individuals who actually needed disability supports, almost 90% of them were receiving them at the time that they received MAID. So I think that what we're seeing is, on the one hand, we may have a resource access question, but on the other hand, we also are seeing persons with disabilities exercising their autonomy and making a choice for MAID, knowing that they also have supports around them. So it may be different issues in play here, not a single issue that we need to be concerned with.
Thank you. Over to Mr. Maloney, Madam Chair. Thank you.
Go ahead,
Thanks.
Mr. Maloney.
Thanks, Madam Chair. I'll try to abbreviate my question. My first question is for Mr. Robert from the CBA, and perhaps Justice Rochon can comment. You've made it clear that the CBA's position is that mental illness should not be excluded in this legislation. As I read your submissions, you support your position in part by saying it hasn't been fully debated yet, which in my opinion would lead me to the opposite conclusion. I'm a little bit confused about that. But and then the second thing is, you said because it's going to be challenged constitutionally. Well, part of the reason we're having this discussion is because that has already happened, and I fully expect it's going to happen again in the future. Maybe if you could expand a little further on why you think mental illness should not be excluded.
Well, thank you for the question. Here's what I would say. On behalf of the CBA, we believe that the response to vulnerability issues is to ensure informed consent. And when discussing the issue of people with mental illness, clearly the issue of those people being vulnerable is being raised. In Carter, the Supreme Court of Canada accepted evidence that vulnerability can be assessed on an individual basis by physicians, and while recognizing that risks are already part and parcel of our medical system, those issues are resolved through the assessment of informed consent on an individual basis. So the issue in the CBA's view with excluding all person with mental illness from the MAID legislation is that, contrary to what the Chouchon decision has concluded, inferring vulnerability on a collective basis in reference to a group seen as vulnerable people may not adequately reflect the diversity of circumstances among that group. So that's why we do support a more patient-centric approach, and that's why we also believe that exclusion of all people with mental illness is subject to constitutional challenge.
Okay, I may not give Justice Rochon an opportunity. I'm going to ask my second question because I'm running very short on time. I was a lawyer for some time before I did this, and I used to hire medical experts to give opinions. And in my experience, the divergence of opinion is much bigger when you come to the psychiatric realm than it is on other illnesses, which is why I have concern about the mental. I have concern about removing the mental health exclusion. The second, one of the other points you make in your submission is this piece with respect to evidence, or experts rather, that it's not necessary. And I understand the context. If you're living in a remote community and whatnot, I grew up in Thunder Bay. I can appreciate that. My concern is, given the expressions of concerns on the mental illness side, are you suggesting that a general practitioner, for example, could give an opinion on mental illness in a MAID situation? I mean, courts don't allow doctors to give opinions outside their area of expertise. I would think the threshold in this situation would be equally as high, if not higher.
10 seconds to respond, Monsieur Roberge.
On behalf of the CBA, I think it's really a case-by-case approach. The concern the CBA has with this blanket requirement is that it may have, again, a disproportionate impact on some individuals. So again, we're coming back. Our position is to support the patient-centric approach that has been adopted by the Quebec Superior Court in Truchon.
Thank you. Thank you very much. We will now move on to Monsieur Thériault for 6 minutes.
6 minutes. Mr. Thériault, please. Thank you, Madam Chair. I would like to be able to hear from 3 individuals. I want to thank the witnesses for their very valuable cooperation in coming before us. I would like to hear from Dr. Arnaud, Mr. Justice Rochon, and Mr. Roberge. Do you believe that we could have a legal challenge under Bill C-7, like we saw under C-14? Do you think that there are provisions in Bill C-7 that will lead to legal challenges that because of people's rights not being respected? So if you could just answer clearly. Thank you. Thank you for my question on behalf of the CBA, and I will not give an opinion really on the probability of Bill C-7 being constitutionally challenged. But as I have said when I gave my presentation, the CBA does see a reasonable possibility of a constitutional challenge, especially with respect to mental health. Thank you. Mr. Justice Rochon, I first want to thank you very much for what you have done in proposing a formula, because you're very clear in your comments. I would like to hear your opinion of the renewal that is required every 6 months, because this is different for neurodegenerative diseases. We're not talking here about the 90 days, but a totally different system that would be applied for. Why are you proposing 6 months for this? If you're on mute. One of the concerns that we have is the emotional reaction that someone can have when receiving a diagnosis of Alzheimer's disease. It is an illness that takes 7 or 8 years to progress, and the person needs time to think about their decision. 6 months will enable that reflection. From what I understand, the thinking process over 6 months would not be renewed every 6 months. Thank you for that clarification. Dr. No, you talked about obstruction. Obviously, patients need a choice. They need to have their dignity upheld, and they need to therefore be respected in their independent decision-making. So I would like you to develop your thoughts a little bit more about that, because at the end of your presentation, you mentioned the need for increased monitoring of refusals. Thank you. You are raising a very good point. When we talk about obstruction, we're talking about people who have signed requests for MAID, legitimate requests, and sometimes the form is thrown in the garbage or it is put on a shelf until the person dies. And then there is pressure on people not to sign or to withdraw a request. And when this type of thing happens, there is no monitoring, there's no accountability. So we know that administration of MAID has been very rigorous. When we talk about unprotected patients whose rights are not respected, then we're talking about these vulnerable people. They have legitimate rights and they are not protected. And we have no explanation as to why MAID was not allowed. Over the past 5 years, we find that the problems have not been with the administration of MAID, but rather the impediments placed in the path of patients for personal reasons on the part of the care providers or the institutions. This is important because when legislation provides for measures, they have to be actually applicable. Do you know whether some institutions, hospitals, exclude patients from palliative care because the patient has requested MAID? Go ahead, please. Thank you. Well, in Quebec, all publicly funded institutions have to provide medical assistance in dying. Only the palliative care centers, that is hospices, don't have to. Half of them now do offer MAID. The other half do not, but there are requests and the patients are sent away from the hospice, have to go to a public institution where they will get MAID because they dared ask for it because they had unendurable suffering. And this is a problem right now in how we deal with patients. Thank you.
Merci, Monsieur Thériault.
Thank you, Mr. Thériault, and thank you, Dr. No.
Mr. Garrison for 6 minutes. Go ahead, Mr. Garrison.
Thank you very much, Madam Chair, and I want to extend my thanks to all the witnesses for appearing today and also for the submissions. I know some of them have been made separately. At the beginning, I always have to express my frustration that some of the issues that we're talking about in the committee go well beyond the mandate of the Justice Committee in studying C7, and I hope that we will have a special committee established which can deal with those broader issues because it's not something that could be solved by adding 1 or 2 sessions to this committee. So my first question is to Monsieur Roberge. We have had testimony which raises questions about why the Truchon decision was not appealed. And I'd like to hear some comments on the relationship between the Truchon and Carter decisions, because I think there is a view that Truchon is set squarely within the parameters of Carter and that some of these basic decisions were actually settled in Carter at the beginning of this litigation. Mr. Roberge.
Well, I'm not going to speculate why the decision why or why not was not appealed in Truchon. That said, I think there are indeed common grounds between the two decisions, that of Carter in the Supreme Court of Canada and the Quebec decision in Truchon. And I think one of the common ground for the CBA is indeed that both courts recognize the need, again, to assess vulnerability on an individual basis by physician. And while there are risks when discussing about MAID for vulnerable people, those risks says the Supreme Court are already part and parcel of a medical system in other kind of end-of-life decision making, and they could be resolved through a proper assessment of informed consent. I'm not going to go into the technicalities of the decision, but while the Supreme Court of Canada decision was grounded as an infringement of Section 7, the Quebec Superior Court also found an infringement to Section 15. I hope my remarks are helpful.
Yes, I believe they are. I want to turn to Dr. Gibson, who raised the elimination of the 10-day waiting period and the establishment of a waiver of final consent. Again, in the context of the court decision where ending suffering was a primary goal, can you comment on what would happen if we failed to change those two provisions?
So one thing we may want to keep in mind is that, in fact, in the two tracks, both of them are recognize suffering as a primary motivation for somebody to be seeking MAID, except in the one case, it's a situation where somebody has already been very clearly has been found eligible and is concerned about losing their capacity. So it's the dynamic of suffering together with potential loss of capacity, which I think has been really underscored. And in fact, and I think just to provide a slight modification in the way we think about what Bill C-17 is doing, it is providing a pathway for advanced consent in a very limited set of cases. So when we think about this, we may want to think about what is the purpose of what was the purpose of the waiting period as it was originally envisioned in the 10 days. It was primarily envisioned as a safeguard against the possibility that somebody may be ambivalent, perhaps, they may change their minds. And I think what we've learned along the way is that, in fact, we speak to clinicians, and also this is confirmed by caregivers and families, that persons who seek MAID, and there's some evidence to support this as well, have stable preferences. They're unlikely to change their minds at that point. And so to eliminate the 10-day waiting period is actually also to be responsive to the suffering that individuals were enduring whilst they waited for that 10-day period to end. So what you might want to think about is how does that thinking perhaps actually extend to the example of the 90-day waiting period, which is actually being proposed for the second track, which is not about reasonable foreseeability of death. And we might also there ask the question, well, I mean, are individuals who approach the prospect of opting for MAID versus continuing in a state of enduring suffering, are they actually not approaching this from the perspective of from a considered view, a well-grounded view? And so the requirement that is embedded there, that there needs to be assurance of clinicians that this has been a well-considered decision, is something which many individuals who are approaching a conversation about MAID are coming in with well-considered views. It may be not aligned with what their families might wish for them. It may not be aligned with what their communities may wish for them. But nevertheless, I think we might want to make a presumption of a well-considered view first, and then explore where there may be situations where, in fact, there may be misunderstandings or a need to really shore up some clarity about whether or not that person is or is not actually vulnerable in that circumstance.
And very briefly, is there any reason to believe that removal of the 10-day waiting period or the establishment of a waiver of final consent would have differential impacts on any particular kinds of patients who are seeking medical assistance and dying?
I don't think we have strong evidence to support that would be the case, but we do know that in Canada, if we look at just what the most recent reporting has been, the reasons according to which people might seek MAID under those circumstances, these are individuals who are eligible already. They've actually reached the point where now they're waiting for MAID to actually be administered. And there's no, I mean, the 10 days is, it doesn't necessarily protect. It actually could create circumstances where persons are actually going to have to just wait longer in a state of suffering after already having had a very solid view on this. So I think it's worthwhile to consider at what point as a patient reach the point of being eligible, making a request, and being willing to wait 10 days. These are stable and well-considered views by this point.
Thank you. Thank you very much, Dr. Gibson. Thank you, Mr. Garrison. We'll now move to Mr. Manley for 2.5 minutes. Please go ahead, Mr. Manley.
Well, thank you very much, and thank you to the witnesses. Thank you to my fellow members of Parliament for giving me the chance to ask a few questions. There are protections and exemptions for mental health in this legislation, and I've been hearing from the disability community in my riding about concerns about people with cognitive disabilities, concerns about people who are nonverbal or have trouble communicating, obviously have suffering in their lives, but is related more to the characteristics of the disabilities that they're born with. And I'm wondering, and I would ask Mr. Roberge if he thinks that there are enough protections in this legislation for people who have characteristics that they're born with and are dealing with suffering, but may not have the capacity to be making these kind of decisions, or may be coerced into making a decision around me.
Thank you. On behalf of the CBA, what is really important, obviously, is access to proper medical care. It's a key factor, and I would leave it to people with more experience, like the physicians who have expertise and experience in this field, who are in contact with the patients, to maybe address your question more directly. But from a legal perspective, I would say that, of course, the quality of the safeguards do matter, as well as the monitoring of those cases. But again, at the risk of repeating myself, for the CBA, it's important to still maintain a patient-centered approach to assess those issues on a case-by-case basis.
Okay.
Mr. Manley, I'm just going to stop you here. Your microphone is not active. I think the sound is not picking up on it. So.
Is that better?
Yes, it is, and
okay.
you have 10 seconds left if you'd like to use them.
Okay, I just wonder if Mr. Node would be willing to comment on that as well, on that same question.
Very briefly, Dr. Node.
Merci. Rapidement. La souffrance.
Thank you very much. The suffering is only one criterion. There are a number of others, and they all have to be met very rigorously. And it includes the capacity to consent, even if the patient does not meet all criteria, then in that case, MAID cannot go ahead. So I do not have any concerns about inappropriate access for patients.
Thank you very much, Dr. Node. I will move to the second round of questions, starting with Madame Finley for 5 minutes. Go ahead, Madame Finley.
Thank you, Madam Chair, and thank you all for being here with us today. Mr. Roberge, in a letter to the Minister of Justice from the Canadian Bar Association dated February 11th, 2020, the CBA wrote, subject to the opportunity to add safeguards to the current criminal code MAID framework, we believe that 2 additional measures compatible with the Carter decision may be considered. A longer reflection period before MAID is administered and a psychiatric assessment. These measures address capacity and consent to the termination of one's life, which are instrumental to the Carter decision. Given this letter from just a few months ago, does the CBA support Bill C-7's complete abolishment of the 10-day reflection period, or what of a shorter reflection period?
Thank you for your question. When the CBA wrote about including a longer reflection period, it was with respect to cases where patients were not nearing death. So I think Bill C-7 does include a longer period for those cases which are described as where death is not reasonably foreseeable. So I think this is in line, although the CBA never expressed an opinion as to a specific delay for a longer period. I think Bill C-7 echoes the comments of the CBA. And with respect to the other aspect of your question, CBA raised indeed the possibility that in some instances, notably when capacity is more challenging to assess for physicians, there might be cases where psychiatric consultation with the psychiatrist could be justified. Again, I think we have some concerns about making it a blanket requirement for all cases to have an expert with specific expertise in the condition causing the patient's condition, while realizing that, again, practitioners could make a referral if they feel they need more specific advice in this regard.
Another question for you. I'm having some concern about what I see as a gap in the logic. I know for me in British Columbia as a lawyer here that if we're doing up a will, 2 independent witnesses have to sign to ensure authenticity and intention, and that's dealing with asset distributions upon death. But under Bill C7, there's only going to be the need for 1 independent witness. Do you see a gap in logic there as I do, or not?
I have to say that the CBA working group on end of life did not address and discuss that issue specifically. So I would refrain to voice any opinion on this issue at this stage.
All right, thank you. My next questions, Madam Chair, for Dr. Naud. Merci d'être avec.
Thank you for being with us today.
Several individuals and groups concerned about the bill that it may harm both the medical profession and our country's most vulnerable. We've received a letter signed by nearly 800 doctors from across the country, which stated, quote, "We watch in utter dismay and horror at how the nature of our medical profession has been so quickly destroyed by the creation of misguided laws. We, the undersigned, declare that the passage of Bill C7, if left unchecked, will contribute to the destruction of much more than our medical profession, but fundamentally of a Canadian society that genuinely cares and values its most vulnerable members." What do you say, sir, to these nearly 800 doctors, obviously your colleagues, who are worried about this bill's impact on both the medical profession and vulnerable Canadians?
Very, very briefly, sir.
Merci, Madame.
Thank you for your question. That represents less than 1% of doctors in Canada. So there's a distinction to be made between doctors that are at the patient's bedside supporting them and that can attest to the rigorousness of the process, and other doctors who have never been involved and often hold these patients in contempt if they have made a request for medical assistance in dying. So it's just a very small proportion of doctors saying this. Thank you.
Thank you, Dr. Naud. We'll now go to Mr. Virani for 5 minutes. Go ahead, Mr. Virani.
Thank you very much, Madam Chair. And in returning to sort of the position about persons with disabilities, Chantal Petitclerc, a senator, stated that in respect of what she heard at committee on Tuesday, that the persons who appeared cannot possibly...
Point of order.
Yes, Mr. Moore.
Sorry to interrupt, Mr. Virani. Madam Chair, do we have a second panel that's starting at 12? Like, are they waiting to start, or when are we wrapping up this panel and starting the other? Because we only have an hour for the next panel.
Right. You're absolutely right, Mr. Moore. As per the discretion allowed me, I just have been feeling over the past number of meetings, we haven't been able to allow our first panels with enough time. So I'm trying to move through as much of the second round as I can to be equitable to all parties. If members will allow, I'd like to, after Mr. Virani, to give Mr. Thériault and Mr. Garrison 2.5 minutes each before we move on to the second panel, if that's okay with everyone. Thank you. Go ahead, Mr. Virani.
Thank you. So as I was saying, Senator Pennyclair had said yesterday in respect of what she heard at committee on Tuesday that, quote, the people that appeared cannot possibly represent and speak for all persons with a disability, obviously because, they don't speak for me. And she further went on to say, nor did they speak for Nicole Gladue or Jean Truchon, the two Montrealers who successfully challenged a provision in the assisted dying law, whom committee members know are themselves persons with disabilities. But I want to ask the former judge, Monsieur Rouchon, and Mr. Roberge a question about the Truchon decision, because a witness on Tuesday actually impugned the integrity of that decision by alleging conflicts of interest and bias in deciding the case, and that in fact there should have been a recusal of Madame Justice Beaudoin in that case. Mr. Rochon, as a former member of the Quebec Court, do you have any comments on that attack on the Quebec Court and its independence?
Well, the decision by Justice Beaudoin was not appealed and really follows in the footsteps of the Carter decision, because Justice Beaudoin affirmed two things that are worth indicating. First of all, that individuals have the right to decide, and also refusing MAID for patients interferes with their rights. So I think those are two fundamental aspects of this decision that are important.
Sorry, thank you. And Mr. Roberge, did you have any comment on that aspect of the Truchon decision?
Not really. Again, it wasn't really within the mandate of the CBA's working group on end of life to address the question you just raised.
Thank you very much, Dr. Roberge. If I could turn to Dr. Gibson. Also, criticism has been volleyed with respect to the consultation that's happened with respect to C7. I personally, as somebody who participated in those consultations, know that they were quite robust, extended to many cities around the country. 300,000 people provided input via questionnaire, 125 experts were engaged, of which I believe you were one. If you could comment on, from your perspective, the robustness of the consultations with respect to C7, Dr. Gibson. Thank you.
Thanks so much for the question. In fact, I must confess, I thought it was far more robust than I might have anticipated, and probably even more robust than what we saw in previous conversations about medical assistance in dying. I think so. From that perspective, I think there were multiple opportunities for folks to weigh in. But I also think, just even looking at the witness lists, the invitations that are being, the individuals and groups who are being invited to this table, I'm really noting that the committee is canvassing a diversity of views, which I think is the strength of this process, augmenting what you've already would have seen from the consultation process across Canada. And so the transparency of these meetings, as well as the reporting, I think serves to provide something that citizens, as well as individuals from protected groups, can look at to see the extent to which their voices have actually been heard. And I think there's been some seriousness taken to ensuring that diversity of views, at least from where I sit, for somebody who's on the outside.
Thank you, Dr. Gibson. Just one final question for you. Can you tell us from an ethical perspective, since you are a PhD in bioethics, about the notion of, as I think you put it in your opening statement, that a 10-day waiting period where people actually deprive themselves of their sedative drugs and what that does for their suffering, simply for the purposes of holding on to the ability to provide final consent. If we're trying to craft a bill and a legislative regime that alleviates suffering, what does a 10-day waiting period actually do for those individuals?
Well, I think, what I was trying to suggest was that when we think about introducing safeguards, we need to think further down the road, not just the protection of, but what the possible impact and implications are. What we've learned is the 10-day waiting period had the unintended and inadvertent consequence of actually extending person suffering, specifically individuals who are eligible for MAID and had well-considered views. So I think it's the impact on suffering, I think, is a real concern for us when we're thinking about safeguards.
Thank you very much. That's all, Madam Chair. Thank you.
Thank you, Mr. Virani. Monsieur Theriault, for 2.5 minutes, sir, please go ahead.
Thank you, Madam Chair. Dr. No, some witnesses and some submissions have indicated that conscientious objections by some doctors should lead the legislators to require referral to another doctor that would administer MAID. So some doctors don't want to administer MAID and don't want to refer. So can you talk to physicians' ethics in that regard? Thank you. That's a very important question, and you are quite right. The conscious objection is a personal value, but must not be applied to patients. So all colleges across Canada impose the requirement to transfer the case to another physician if they have a conscientious objection. So provincial colleges have this requirement. I can make an analogy with blood transfusions. If you are a Jehovah's Witness and a physician, you might want to refuse to provide a blood transfusion, but if you don't refer to another doctor, then that is a very serious ethical breach. A doctor certainly has the right not to participate in MAID. That is part of their rights, but they need to refer, and the legislation should include that requirement because it isn't to protect the doctor's religious or other rights that we should address. Well, there are a lot of different types of physician practices. So when we talk about MAID and the need to help patients at the end of life, do you believe that we have enough parameters around that? A lot of progress has been made over the past few years, especially in Quebec, and that's the jurisdiction I know the best. All physicians are being given information, and the students are certainly being given the information, and they know how to provide this type of care.
Thank you, Dr. Nod. Thank you, Monsieur Theriault. Mr. Garrison, please go ahead for 2.5 minutes.
Thank you very much, Madam Chair. I'd like to pose the same question on conscience referrals to Dr. Gibson and hear what she has to say on that topic.
Yeah, thank you for the question. I think it's well recognized that individuals entering into a profession are acting from conscience, whether it is to provide and assess or not to participate at all in medical assistance in dying. So it's important for us to continue to protect the conscience of professionals in general. And at the same time, there are duties of professionals to society as well. And so many of these systems that have been established across provinces and territories to be able to link patients to providers who are willing to provide have been ways to find that balance between protecting the conscience of a professional and protecting the right of individual patients. So I think if you know, in Ontario, there is a duty to refer. And I know that for some health professionals, that is seen to be something that is not concordant with their conscience. But this is where there are systems now in place for patients to be able to link to a willing provider that actually does not put health professionals in a compromised position.
Thank you very much. Just very briefly, on the question of requiring special expertise in the second track in order to make assessments on eligibility for medical assistance dying, can you comment on what impact that a strict requirement like that would have in rural and remote areas in Canada?
So one of the things that we have now within, it's partly as one of the gifts of COVID, is a much better and integrated network of providers facilitated partly by virtual types of supports. But one of the things we've also heard from clinicians is that often they're dealing with patients who are complex patients. And in fact, many of the providers themselves are very well versed in being able to understand and appreciate the clinical consequences of the particular patient in front of them. So while drawing on expertise, this is part of clinical practice regularly, where there's uncertainty, colleagues will reach out to colleagues to get insight and advice. I think we already see that as a key feature, an essential feature of clinical practice already, that in fact, instituting this as a legislative matter may actually reach beyond what is actually sufficient in order to provide relevant input and expertise in the care of a particular patient, just as a result of regular clinical practice.
Thank you.
Thank you very much.
Thank you very much. At this time, I'll thank all of the witnesses for your testimony today. and for your contributions. If there are any further clarifications you need to provide, please do write to the clerk of the committee with any additional information based on the questions today. At this time, I'll suspend the meeting for 30 seconds to allow for our next panel of witnesses to come in. Thank you, everybody. Welcome back, and I'd like now to welcome our second panel of witnesses. We have the Canadian Nurses Association represented by Michael Villeneuve. We have the Canadian Society of Palliative Care Physicians represented by Dr. Anne Boyle and Dr. Harvey Max Chachinov. Excuse me if I didn't pronounce that correctly. We also have Disabled Women's Network of Canada represented by Bonnie Brayton. And lastly, Physicians Alliance Against Euthanasia, represented by Dr. Catherine Ferrier. So we'll start. Each of the witnesses, each organization will have 5 minutes. We'll start with the Canadian Nurses Association. Go ahead, Mr. Villeneuve. You have 5 minutes, sir.
Thank you, Madam Chair and members of the committee. Good afternoon. I'd like to acknowledge the Algonquin Anish peoples from whose traditional lands I'm speaking to you today. And thank you, Madam Chair and members of the committee, for responding to CNA's request and extending an invitation for us to speak on Bill C7. We're honored and grateful for the opportunity to appear before the committee in the year of the nurse and midwife. And I don't need to tell any of you that it has not been quite the year of celebration that we had planned. I have worked in health systems for more than 40 years, and 37 of those as a registered nurse. And I've had the honor of serving as the CEO of the Canadian Nurses Association since 2017. CNA is the national and global professional voice of Canadian nursing, and we represent nurses living across all 13 provinces and territories and in hundreds of Indigenous communities. Canada's 440,000 nurses touch the lives of patients at every point of care constantly, and no provider has as much face time with the public where these really complex human moral issues arise. The transformative legislative and moral decisions being proposed carry huge impacts for nurses who are responsible to live with them and enact them in their practice every day. Nurses are an integral part of the delivery of medical assistance in dying, and it is vital that the committee hears their voices. We have acquired significant knowledge and perspectives and experience from nearly 5 years of MAID in practice and valuable perspectives to inform the impending changes to the legislation. CNA has been actively involved in work related to MAID for several years and was a key stakeholder when Bill C-14 was passed in 2016, as well as during the consultations earlier in 2020. CNA advocates for safeguards to protect the rights of patients and nurses, as well as for system-level changes, including better access to palliative care and accountability mechanisms. I'll turn briefly to Bill C-7 now, Madam Chair. Overall, CNA believes that the federal government has listened to our initial feedback during the consultation phase earlier this year. We were pleased to see that some of our recommendations were included, such as the removal of the 10-day reflection period, removal of final consent for those who lose capacity, and amending the legislation to allow for one independent witness. Regarding the new stream for cases where natural death is not foreseeable, we heard from experts that the proposed safeguards are adequate and sufficient. We emphasize that legal expertise for updating MAID guideline documentation will be critical to ensure that all new items in the legislation are acknowledged and fully understood by patients and practitioners. In general, while we're supportive of Bill C-7, we believe that further improvements and additional clarification in 4 areas would strengthen the legislation and provide better care for patients and legal protection for nurses. First, CNA strongly recommends that Bill C-7 include an additional 5-year period of MAID by a committee of period of MAID by a committee of Parliament. Second, we recommend removing the wording that stipulates that the practitioner providing MAID does not know or believe they're connected to the other practitioner who assesses the MAID criteria. We recommend clarifying that practitioners can initiate a discussion on the lawful provision of MAID. And fourth, we recommend clarifying the proposed preliminary assessment clause, which we find confusing, and that's causing concern among nurses. Furthermore, we strongly recommend that parliamentarians conduct as soon as possible the broader review of MAID to address important issues beyond C7, Bill C7. In concluding, Madam Chair, CNA would like to state its gratitude to the Canadian Nurses Protective Society, who's been an important partner in our MAID-related work. We've submitted a written brief to you with more information, and I'm glad to try to answer any questions. Thank you again, Madam Chair, for the opportunity to speak to this committee today.
Thank you very much, much appreciated. We'll now move to the Canadian Society of Palliative Care Physicians, Dr. Anne Boyle and Dr. Harvey Max Chochinov. You have 5 minutes between the two of you.
Thank you, Madam Chair and committee members, for this opportunity. I am the current president of the Canadian Society of Palliative Care Physicians. I worked as a northern nurse and have over 32 years experience as a physician. Since 2004, after a year of additional palliative care training, I have worked as an academic palliative care physician, seeing patients wherever they call home. Addressing suffering is both imperative and challenging. Our hope is to ensure necessary services are in place to address suffering and safeguards are in place to minimize harm. 98% of Canadians will not choose a hastened death, and 100% of Canadians need palliative care enshrined in the Canada Health Act as an essential service, so that all patients may receive impeccable care in the location of their choice and be able to live well until they die. All Canadians deserve...
Ms. Boyle, if you can please move your microphone a little bit above your lip so that there's no popping sound for the interpreters.
All Canadians deserve access to high-quality, comprehensive palliative care. Dr. Chochinov will now speak.
Thank you, Madam Chair. I believe that the data I will share is important for the committee to consider. The following are excerpts from my written submitted brief. By way of background, I'm a distinguished professor of psychiatry at the University of Manitoba, former chair of the external panel on options for a legislative response to Carter versus Canada, and a longtime palliative care researcher who has published extensively on psychological matters pertaining to palliative care. Bill C-7 proposes the elimination of any waiting period between the time a dying patient is approved for MAID and the administration of MAID. Our research group reported that will to live can be highly fluctuant over intervals as short as 12 to 24 hours. 40% of patients who are prescribed lethal drugs in Oregon, in fact, decide not to take a lethal overdose. Bill C-7 also proposes to eliminate the requirement that a patient have a reasonably foreseeable death. For patients whose life expectancy can be measured in years or even decades, Bill C-7 recommends a 90-day assessment period. The suicide rate in many chronic conditions is very high. A study of 496 patients with traumatic brain injury, stroke, or spinal cord compression reported that most of those who were initially suicidal no longer were 3 to 24 months later. Bill C-7 also indicates that it will no longer be a requirement to reaffirm competency at a time of administration of MAID. The Netherlands allows for a euthanasia advance directive for those who fear losing capacity. A survey of 410 Dutch physicians reported that only 3% had ever complied with the advanced euthanasia directive. Compliance with an advance directive was almost always raised by someone other than the patient. In 72% of instances, the relatives or representatives did not feel comfortable proceeding with euthanasia, but instead settled on foregoing life-prolonging treatment, as did their physicians. Finally, while Bill C-7 indicates that mental illness alone is not enough to qualify for MAID, mental illness is often accompanied by medical conditions. Together, this may open up the door to MAID for these patients. A landmark Dutch study of patients with psychiatric disorders who had received euthanasia or assisted suicide in the Netherlands showed that nearly 60% also had medical problems such as cancer, cardiac disease, stroke, or neurological disorders. They suffered from depression, psychosis, grief, even autism, conditions that require exquisite and concerted psychiatric care. In conclusion, the data suggests caution regarding the following legislative amendments. Number one, the data indicates that the wish to die and desire for death in the context of terminal illness can fluctuate widely over time. Hence, some period for reflection would seem prudent. Two, the wish to die amongst patients suffering from non-imminently life-threatening conditions, including chronic illness and disability, is not uncommon and can fluctuate over the course of months to years. When the determinants of the wish to die in patients living with these chronic conditions or disabilities are addressed, suicidality can wane. Number three, the data strongly indicates that neither physicians nor relatives feel comfortable providing MAID to patients who are unable to state their wishes or convey that they are suffering intolerably. And finally, four, eliminating the provision of a reasonably foreseeable death opens the door for patients with various chronic medical conditions and disabilities, including those with concurrent mental illness. All of these facts are critical in understanding and mitigating the suffering of those who have lost their will to live. Thank you for your kind attention.
Thank you very much for that, Dr. Chochinov. We'll now move on to the Disabled Women's Network of Canada. Ms. Bonnie Brayton, please go ahead. You have 5 minutes.
Thank you, Madam Chair and members of the committee. Greetings to other panel members. Thank you for inviting me to appear today, and I'm speaking from the unceded territory of the Kanaka people. I remind us that truth and reconciliation is not about words, it is about how we conduct ourselves in the face of truth. We remind the committee that according to Statistics Canada, 24% of women in Canada live with a disability. Dawn Canada is in its 35th year of service, and yet we do not celebrate. We oppose the removal of the imminent death clause. This is a fatal error, one that you as lawmakers will have to live with. Evidence is absent now as you move this forward, but you will be judged on the evidence, and unnecessary deaths you could have prevented if you do not take a pause now, today. You are all of relative privilege, as am I. In preparing for today, we've referenced documents which we leave with the clerk to share and in a go forward. We will also forward with permission the story of a strong, brave woman named Ruth, a fierce advocate whose situation is the reason you must take pause. In a different Canada, Ruth would receive the support she needs to have a life that has meaning, including dignified housing that keeps her safe and alive. She is intelligent, articulate, and would be a good mentor and counselor to anyone who lives with environmental sensitivities, and she knows the ropes. But instead, in her own words, my doctors are well aware of my thoughts about MAID and have been trying to find me a new home so that I wouldn't resort to using this process. But there is no safe, affordable housing for people like me. While I don't really want to go through with MAID, I cannot continue to live in these conditions forever. Because of, you see, Ruth, like so many other people with disabilities, has lost hope. She's not dying, but she meets the new criteria for MAID. We've also shared our submission to FEWO on the implications for women with disabilities in the context of MAID, which of course will interlock with the discussions today. I also share from the Ethical Principles for Judges Handbook, edited by Beverly McLaughlin in 2014, Chapter 5, Equality Principles. The Constitution and a variety of statutes enshrine a strong commitment to equality before and under the law and equal protection and benefit of the law without discrimination. This is not a commitment to identical treatment, but rather to the equal worth and human dignity of all persons, and a desire to rectify and prevent discrimination against particular groups suffering social and political disadvantage. One of our most learned judges makes a deliberate decision in this chapter to cite Eldridge versus British Columbia, an intervened case at the Supreme Court that centered on systemic ableism in the medical system involving a deaf woman who sought her right to health care and to motherhood itself from 1997. In 2012 and again in 2020, Dawn have intervened again in Supreme Court decisions which affirm women with disabilities and their equality rights while reminding all of us that women with disabilities must be believed. Over-reliance on generalities in the most recent decision, Slatter, on November 6th, reads, over-reliance on generalities can perpetuate harmful myths and stereotypes about individuals with disabilities, which is inimical to the truth-seeking process and creates additional barriers for those seeking access to justice. Today, for Ruth, what is your message to a desperate, courageous self-advocate during the worst health pandemic in a century? Is this our best answer, really? No, Ruth, we cannot help you. It's just too hard for us to do that, but we can offer you MAID, really. You have a moral, legal, and sworn responsibility to our Constitution as legislators. It is clear from the highest court in the land that you must, above all else, make laws that respect these tenets and do no harm, and you must do so based on balanced evidence and information about those who will be affected by them. Thus far, you have failed in your duty with D7. You have no evidence to support your hurry to pass this bill. You answer to us, all of us. You gave us the Accessible Canada Act after a rigorous, inclusive human rights consultation with people with disabilities. Why not now? This is Indigenous Disability Awareness Month, and as I sit before you, I know we have not had full consultation from a human rights place with Indigenous people with disabilities, with women with disabilities, and with the majority of those being people that need to be heard in this case. Thank you.
Thank you very much, Ms. Brayton. We'll now move on to the Physicians Alliance Against Euthanasia. Dr. Catherine Ferrier, the floor is yours for 5 minutes. Please go ahead. You're on mute, madam.
I'm a physician and I've worked since 1984 in the geriatric clinic at the McGill University Health Center. My focus is on care for patients with cognitive disorders. I often do capacity assessment and testify in court for my patients. My colleagues ask my advice on capacity assessment and refer me their most difficult cases. Before seeing a patient, I collect all the information I can from the family, social worker, and other sources. You can't assess capacity without knowing what decisions the patient is facing, the constraints, and the reasons why they consider certain choices to be harmful to the patient. I typically spend 2 hours with the patient and sometimes need to see them more than once. When we assess capacity, we try to enter into the patient's mind to determine whether any cognitive or mental disorder is interfering with their ability to understand the information needed to make decisions, appreciate how it applies to their situation, reason, and express a choice. We also weigh the degree of risk associated with the decisions they have to make, and this may influence our conclusion. All this explains why experts may disagree about the capacity of a patient. Beyond capacity is the question of agency. There's no such thing as an autonomous decision free from constraints. This is true for all of us. Internal constraints include fear or other emotions, habit, lack of knowledge of options, or a desire to please others. External constraints include marginalization, a lack of options, and pressure from others. That's why the federal correctional investigator called for a moratorium on MAID for prisoners. Another example of lack of full agency is abuse, where competent adults remain in situations that are harmful to them. I see many victims of elder abuse. One was a widow from Eastern Europe with no relatives in Canada. A woman pretending to be her niece fraudulently obtained a power of attorney, emptied her bank account, and moved her to a nursing home against her will. She ran away in midwinter with her walker and was later brought to me for assessment. She didn't have advanced dementia as alleged. She was not fluent in English, but was fully capable. She lacked the agency necessary to defend her rights without help. Suicide is another example. The CCA expert panel couldn't reach a consensus on whether there's a meaningful difference between suicidal desires and a desire for MAID. The suicide rate after traumatic spinal cord injury is 20 times that of the general population for 5 years. Those who choose suicide may not be depressed or incapable of decision-making. Their options have been tragically narrowed, and it takes a long time to readjust. But people do. After 5 years, the rate is the same as the general population. They need protection from their despair. That's why our society responds to suicidal desires with prevention. That's why we can't allow MAID after 90 days. Bill C-7 creates a framework for people not near their natural death that only requires provision of information on other means to relieve suffering and a 90-day waiting period. Giving information has no value if access to the service is not available. It's largely not within that time frame. Often there's not even time to see a specialist, certainly not time to regain some hope of healing. The bill is proposing a criminal code amendment to permit doctors to end the lives of Canadians whose suffering has not been addressed in other ways. We're told that the numbers will be small. Beyond disabled persons who made their point clearly on Tuesday and today, we could look at a few common medical conditions we see in our practices. Over 2 million Canadians live with chronic obstructive lung disease. 600,000 live with heart failure. There are 700,000 stroke survivors and 5 million people with osteoarthritis. Of course, not all these people will seek MAID, but many of them will be eligible. They have a serious and incurable illness. The question of whether they're in an advanced state of irreversible decline in capability is subjective, as is the presence of enduring physical or psychological suffering that is intolerable to them. Everyone with an acute or chronic condition that causes suffering and loss of autonomy will lose the protection of the criminal code, which will be reserved to the young and able-bodied. Ageism and ableism are rampant. Seniors and people with disabilities are denied care because their life is seen as less valuable than other people's. To leave to doctors the decision about providing MAID to anyone who meets their criteria is to entrust them with life and death decisions for millions of people in a vulnerable position. Doctors have the same limitations as everyone else, which may include unconscious bias towards MAID as an option and against living in certain situations. No one should have that power. It should be made clear in the law that MAID is not a medical treatment on the same level with real treatments. It's not a standard of care. It should be a last resort when all other reasonable options have failed. Thank you.
Thank you very much for that, Doctor. We'll now go into our first round of questions, starting with Mr. Cooper for 6 minutes. Go ahead, Mr. Cooper. The floor is yours.
Great. Thank you very much, Madam Chair, and thank you to the witnesses. I'll address my first question to either Drs. Boyle or Professor Chochinov. At our last meeting, we heard compelling and disturbing testimony from Roger Foley, who talked about the fact that physician-assisted dying was specifically brought up to him without him initiating it, and that he faced considerable pressure and coercion from healthcare professionals. Now, in your brief, you make note of that concern, and you state expressly that healthcare professionals should not initiate such a conversation. Why do you believe that that should not occur? And further to that, can you speak to how the Australian state of Victoria has responded legislatively, and would you support a similar safeguard to be legislatively introduced when we consider amendments to Bill C7?
Thank you, Mr. Cooper. I think we're all aware that there is a hierarchy and differential of expertise in the physician-patient relationship. And it is actually addressed directly, as you mentioned, in the Victoria law in Australia. We feel that it's important for patients to raise it, and if they do, for their questions regarding MAID to be addressed by all healthcare professionals and the issues explored, including their underlying suffering. And they should be provided information or directed to someone who's able to provide that information. But we actually support and urge the federal government to reduce harm to vulnerable patients by including this in the current revisions to the Canadian MAID legislation.
Great, thank you for that. Another area of concern raised in your brief was with regards to the 90-day waiting period where death is not reasonably foreseeable. We have heard similar concerns expressed from other witnesses. Can you speak to the inadequacy of a 90-day period from the standpoint of accessing services, whether it be palliative care or psychiatric or psychological supports or counseling, let alone the adequacy of time in order to have meaningful palliative care treatment, for example, up against a 90-day clock?
Yeah, the 90-day clock, as you put it, is very problematic. There have been a number of studies, for example, a Manitoba study that actually found that after 90 days of being diagnosed with a major physical impairment, patients reach a peak in their suicidal ideation. They continue to be suicidal, although it wanes, but as much as a year later and thereafterwards, it is still greater than their match cohort. So 90 days is certainly not an opportune waiting time. The other thing is that we know that it takes a great deal of time for these people to be able to avail themselves of expertise. So, for example, patients who are highly at risk, for example, those with chronic pain, may have to wait as much as 6 months or more, depending on what part of their country they happen to live in order to get access to care. My specialty is psychiatry, and again, the waiting list for good psychiatric care is in the neighborhood of months to up to a year, depending again on what part of the country you're in. So the 90 days is problematic for all of those reasons that in large measure is data-driven and data-informed.
As well, I think that what Dr. Ferrier mentioned, that simply having information about available treatment options is not enough. People actually need the lived experience of having care in order for them to make informed decisions.
You're on mute, Mr. Cooper.
Thank you, Madam Chair, for pointing that out. In terms of addressing this 90-day period, how do we fix this in the way of amendments? What would you propose instead to the same witnesses?
Well, I mean, I think, you know, the 90-day period is problematic. I know that Dr. Ferrier also cited the studies which looked at patients who had traumatic injuries and found that anywhere from 3 to 24 months later, patients continued to experience suicidal ideation, and over the course of that time saw also changes in their suicidal ideation with the advent of treatment or care. So I would say that it's important that we maintain the reasonably foreseeable death clause, because without that, there is really no differentiation between MAID and those who are seeking out suicide for suffering that might be amenable to treatment.
And I guess one other point just to finish up on the 90-day period is it's 90 days from the time of assessment rather than the time of that one actually executes their wish to proceed with the procedure. Do you see that as problematic? And
you're out of time, unfortunately,
okay, well,
Mr. Cooper. But we hopefully will get to that to the next round. I'll move on to Mr. Kellaway for 6 minutes. Go ahead, Mr. Kellaway.
Thank you, Madam Chair, and hello to my colleagues and the witnesses today. Thank you for being here. It's truly an honor and a privilege to have you here. My question will be directed towards Dr. Bonnie Brayton. So, Madam Chair, former federal cabinet minister and Manitoba member of the Legislative Assembly, who has been living with quadriplegia since the age of 23, recently spoke to the debates around the MAID legislation. And Stephen Fletcher said that given the large range of disabling conditions, that no one, including disability right groups, can decide for someone else what is tolerable. He said that new safeguards and talk of protecting the vulnerable are, quote, insulting and condescending. I'm going to further quote Mr. Fletcher here. He says, quote, everyone is a minority of one. From that perspective, everyone should have all the rights and responsibilities as everyone else. And when you look at it from that perspective, all those other arguments don't make any sense anymore because we're going to protecting the rights of everyone, period. End of quote. So, Madam Chair, I think of groups in my riding who are huge advocates for inclusion for individuals with varying physical and intellectual disabilities. And just thinking of inclusion and the words of Mr. Fletcher, I'm curious to hear your thoughts, Dr. Brayton. Do you agree that we should all have the same rights and responsibilities as everyone else, and that by not allowing some to participate in MAID would be moving backwards in terms of inclusion and an infringement on their autonomy as an individual? Thank you so much, and I look forward to your answer.
Oh, thank you for assigning me a doctor's degree. That's wonderful. I appreciate that very much.
I'll give you one if you give me one.
Thank you. I will be very blunt. Mr. Fletcher is not an expert in this area. Mr. Fletcher is a white male who's involved in other work, but is not an advocate for people with disabilities and has no history of looking at the research, the situation. And many of the points raised, I think, by the panelists here would not be something that I would consider Mr. Fletcher expert on. So while I have no disrespect to Mr. Fletcher or even to Senator Petitclerc in terms of their positions on this, I would remind everyone that these are people who are a member of the political class, and they are not members of the communities that we are talking about and for whom we express concern regarding these changes. And to be really clear, I think if we want to really push this out all the way, and I'm not comfortable doing this, but I think the point needs to be made, if you'll pardon the obvious and not intended pun, is that if we understand that singling out a rights group in the context of this legislation, specifically saying that it is people with disabilities for whom this applies, is what is problematic. And that if Mr. Fletcher takes his argument all the way to the limit of his perspective, that what we end up with is the possibility that everyone should have access to MAID. And of course, we don't think that that's the right solution. I think a lot of experts here have made it really clear that palliative care and other solutions are what we need to address the kinds of problems that drive people to a place where MAID is the only option they have instead of good palliative care or a quality of life, as with the example I shared earlier in terms of Ruth. And so I believe, like I said, that while I understand the concept, I think there's a real problem here in terms of the reality, because we're talking about people who are extremely vulnerable, not about Mr. Fletcher. Thank you.
Thank you for your answer. I appreciate it. I'd like to stay on, I guess, a similar line of thinking, and I was going to say Dr. Brayton again. I almost gave you 2 doctorates. Disability advocates participated heavily throughout the consultations, and we truly value what we heard from these groups. And that's why we believe that this legislation strikes the right balance of autonomy and protection of vulnerable people. But I'm wondering how you would suggest, Ms. Brayton, striking the right balance of protection of vulnerable people and also allowing them to maintain their autonomy. I wonder if we can do a deeper dive on that if possible.
You're on mute, Ms. Brayton.
I think what's really clear is that there aren't enough protections, that there aren't enough social protections for vulnerable people, Canadians, including people with disabilities. And that the reality is that this legislation is an aspirational piece of legislation that, while I understand some people believes is towards enshrining the rights of individuals to make choice, that they have missed the reality check I think we all have to have. The majority of human rights complaints in this country are disability related, sir. The United Nations has expressed concern to Canada with respect to even entertaining this kind of change in legislation. And I really believe that it's an important opportunity for legislators to take a moment, take pause, to do the 5-year review, as has been suggested by other members of this panel, and to slow down this process. It's critical that we take a step back. As I said, I don't think anybody here wants to regret making an egregious decision in legislation that's going to take away people's lives. And I'm afraid that's where we are. That's not based on anything that has been presented here, of course, because we haven't had objective evidence presented. And I think that's another key issue. Thank you.
Thank you very much. How much time do I have left?
You have 30 seconds, Mr. Kellaway.
I will forego the question because I may give Ms. Brayton a 3rd doctorate. So I appreciate your insight and your perspective. Thank you so much.
Thank you so much, Mr. Kellaway.
Thank you so much. We'll now move on to Monsieur Thériault for 6 minutes. Go ahead, Mr. Thériault.
Merci.
Thank you, Madam Chair. And I want to thank all the witnesses for their valuable contributions. The dignity inherent to every person is not something that should be addressed lightly, and we need to support self-determination. The patient should have the right to free and informed consent. So we're talking about free and informed consent. Ms. Verrier, in that context, why should we not allow for medical assistance in dying as an option? Can you hear me if I speak in French? Does that work for everyone? Do you have interpretation? Yes? Very well. So you think that you're saying that the doctor or the patient should have that choice? Yes, patients should have a choice. Of course, it needs to be a free and informed consent. So why not recommend that that be available? Very well. I gave you some figures earlier about the number of people that would be qualified to have access to MAID, and we're talking about millions of people. But let's talk about people who are in the terminal phase of an illness. Well, in fact, now it would not be extended only to that group. I want to talk about that particular group. Well, there are people who are at the end of their lives, and most of them do not want to die more quickly. They want to live as long as possible. The fact that a doctor or a nurse can be actually allowed to say, well, you have the option to end your life. This is a way of removing some of the independence of these patients, because it suggests that their life is not worth continuing. But I'm sorry, I just want to interrupt, says Mr. Thériault. But obviously, it is not a case of life not being worth living, but Rather, the disease is active, is irreversible, and there is palliative care that should be used to the maximum. But since palliative care should accompany people as they move toward death, why not allow for requests to have assistance in dying? Why is that not a reasonable choice to have a calm death? Why is that considered a failure rather than a success, to have support in dying? I think you've changed the topic. No, I haven't. I was talking about requests. Well, in fact, when we're talking about requests, then patients have to be aware that they have the option. I don't think there's any problem with that. People are bombarded with information in the media and elsewhere. On the contrary, it's hard to defend palliative care. I think this is a question you should ask people involved in palliative care. For the last 45 years, we've had Dr. Saunders express views on that. And up to 2020, all organizations advocating for palliative care have indicated that MAID is not part of palliative care. We've also heard people say that the desire to die can fluctuate a great deal from one day to the next, one time to the next. Life maybe their situation may be addressed by palliative care resources. Some people have said that we as legislators should allow for physicians to refer patients to another physician. Do you agree with that? Yes, I agree. Does that not breach your code of ethics? Well, the code of ethics was amended by the College of Physicians to address MAID. I feel, and others feel, that the focus has to be on care that actually helps patients, not care that harms patients. We need to avoid giving medication and other treatments that will harm patients. And I think that, for example, if we had a surgeon that was going to, that refuses to do a type of surgery, it doesn't require a referral to someone else. We're not talking about surgery, but rather the end of life here.
Thank you very much, Monsieur Theriault. We'll now move to Mr. Garrison for 6 minutes. Go ahead, Mr. Garrison.
Thank you very much, Madam Chair. And with apologies to my colleagues at the beginning of each panel, I feel obligated to point out that many weeks ago, I introduced a motion on the order paper in the House of Commons calling for the commencement of the statutory review, which would have both the mandate and resources to deal with some of the very important questions that have been raised here with regard to palliative care and people living with disabilities. This time I would also note, though, that if we do not proceed with C7, then court decisions will guide the medical practice on medical assistance in dying. We've heard a lot from physicians, as we should, about the issue of medical assistance in dying, but today we also heard from nurses, and I would like to turn to Mr. Hamza because I think he's raised some issues we haven't heard about before in our inquiries. And I know one of his recommendations is dealing with the question of whether nurses and nurse practitioners will be in jeopardy if they raise the issue of medical assistance in dying with patients. Could you elaborate on your concerns in that area, Mr. Hamza?
Sure, and I'll just tell you that my colleague, who was Miss Hamza, was unable to be with us. It's fine. No, it's fine. Just for your record, she's lovely though. Yes, we have. So we have concerns in a number of areas, but as I've been listening to the very interesting comments today, I want to just frame that patients have very intense, intimate conversations with nurses in ways that it's just hard to describe. I can tell you, and I spent most of my clinical practice over the first 20 years of my career in neurosurgery, spinal cord injury, brain injury, many of the kinds of things we've been talking about. And patients and families will often say something to a nurse at 3 o'clock in the morning in the quiet darkness that they wouldn't say anywhere else. And we have, I can tell you many times, we raised issues, tough things, abortion, treatment decisions. Why are you refusing chemo when it could help you? And nurses told us in the study that we've been doing over the last 3 years in preparation for the larger review, that they feel hamstrung by that, and that there were opportunities. We counsel people on the broad range of services in healthcare, whether we're in a women's clinic or a neurosurgery clinic and so on. So it's not a, I'm worried that it be framed that it's advice you should. It's rather, is this something you thought about? And very, very often, people will not raise about it for a long time. We want nurses to be protected so that they can have those conversations about the possibility that it may be in the patient's mind.
Thank you very much. I apologize for missing the switch in witnesses. My only excuse is on the West Coast. I have to start very early here. Can you say more about the other issue that you raised about the issue of knowing or being connected to other practitioners or assessors? And I'm assuming this is a large problem in smaller centers.
It is. So we've been concerned about what might happen, for example, in many Indigenous communities where there may only be 1 or 2 providers, often just nurses, not just, but nurses versus physicians, I should say. But that's a bit of an extreme. The example I will share is I've just finished my term, 2 years as the board chair here at Winchester District Memorial Hospital in Eastern Ontario. And I can tell you as a rural person of some 20 years or so now, everybody knows everybody. And yes, we can certainly make a phone call and have an external assessor from a different community come in. But all our physicians know each other, they know the nurses and so on. So we are concerned that that could hamper the process and hold it up. And nurses, or I should say physicians and nurses, are deeply ethically bound to a certain code of behavior, and knowing or not knowing the other provider should not lead to coercion, if that, or conspiracy, if that's the fear.
Thank you very much. I think, Madam Chair, in the interest of time, I will conclude my questioning there.
Thank you very much, Mr. Garrison. That was very generous of you, a minute and a half. I will now go on to Mr. Manley for 2.5 minutes. Go ahead, Mr. Manley, your time starts now.
Well, thank you very much, and I'd like to thank the witnesses for appearing today. I have a question for Dr. Chochinov about the suicide ideation. We should be looking at different types of diseases or decline in health and parsing that out to provide different timelines for different people. I mean, some of these diseases have an obvious rate of decline, and we talked about people becoming quadriplegics. Obviously, then there's that's not a continued state of decline. That is an accident that is, or something that's cut somebody off. So I'm just wondering whether you would see amendments that would maybe look at the state of decline, or yeah, what would you see for amendments that might work in these kind of situations?
Yeah, it's a difficult question because we're trying to address the issue of suffering and how we can respond to patient suffering, and using a tool that is particularly crude, that is by euthanasia or assisted suicide. Suicidal ideation is not uncommon in the general population. There was a Canadian study that showed about 13% of people over the course of their lifetime will experience suicidal ideation. About 4% of them will go on to have plans, and about 3% of them will in fact make an attempt. But the rate of completion is only about 14 out of 100,000. So suicide continues to be relatively rare when you think about it in the context of the number of people who have suicidal ideation. As I was pointing out, and as Dr. Ferrier pointed out, there are conditions like spinal cord injury, stroke, head trauma, and we know if we follow these patients over time, as much as 24 months after the fact, they can continue to be suicidal. So I think we're going to have to look at individual illnesses and the trajectory of suicidal ideation in order to know how to shape legislation, if it's even possible. Again, I would suggest that the reasonably foreseeable death at least provides a differentiation between MAID, which is medical assistance in dying, versus suicide, which is for people who no longer want to face the prospect of further life.
Thank you very much. That brings you to your 2.5 minutes, Mr. Manley. At this time, right prior to going into our second round of questions, I seek the consent of the committee. If we just go 5 minutes conservative, 5 liberal, 2.5 bloc, and 2.5 NDP. If you can just give me a thumbs up for us to continue in that way. Mr. Garrison, I don't see your thumb. I just want to make sure you're okay. Okay, all right, we'll go ahead then. So I have Mr. Moore next for 5 minutes. Go ahead, Mr. Moore.
Thank you, Madam Chair, and thank you to all the witnesses today for their important and relevant testimony. Dr. Shoshanov, I have a question for you. We've heard from witnesses who are especially concerned about the impact around this bill will have on persons with disabilities. We heard even this week from groups representing persons with disabilities. And do you have insight? There's been some discussion here about now for those who death is not reasonably foreseeable. Number one, for those where death is reasonably foreseeable, we're removing the 10-day waiting period. But where death is reasonably foreseeable, or is not reasonably foreseeable, putting in a new 90-day period. And we've heard from several that is wholly inadequate, the 90-day period, because for some people, they may barely have begun a treatment on that. Could you provide any insight that you may have around this 90-day period between when someone could request MAID or assess for MAID and then receive MAID when they are not, when their death is not reasonably foreseeable?
Well, again, I mean, the 90-day is a problematic time frame. Again, I harken back to the Manitoba study that I mentioned. This was a study that looked at groups of people who had suffered from some physical ailment. And from the time of diagnosis and 90 days hence, they found that these people were at their maximum in terms of suicidal ideation. So we know that there is a period of adjustment after one has had a change in one's physical status as a result of a physical or mental illness that can manifest itself as a result of, that can manifest itself in the way of a wish to die. Again, the other study that I mentioned, and again, I think it's worth looking at the numbers. When you look at people who have had strokes, who have suffered from disabilities as a result of spinal cord injuries or head traumas, there's studies that have followed these people as long as 2 years after the fact. Interestingly enough, when you look at those people who were initially depressed and then receive treatment for depression, all of them will in fact go from a state of being suicidal to a state of no longer being suicidal. So again, what I would underscore is that when you're looking for people whose death is not reasonably foreseeable, what these people need are supports, disability supports. They need a limitation of access to means, because we know that the more people have access to means such as guns, and just as a side note, the suicide rate in the United States is more than double that in Canada, and it's thought that it's probably because of access to guns. So if we limit the access to means, and if we provide people with treatment, we know that we can see people who will renege their suicidal ideation. As a psychiatrist, I've worked with people who have had chronic suicidal ideation over periods of even years. They continue to struggle, but what one does in good psychiatric care is give an unwavering commitment that we will be there with that patient. We engage in a relationship with that patient. And these individuals have gone on to lead lives that are productive. They are loved and they do love. They have raised families and they have a meaningful existence.
Thank you, Doctor. And Dr. Ferrier, there was made mention in testimony today about those, there's the distinction with those whose only underlying issue is one of a mental nature, but the point was made today that there's often other underlying medical conditions for those people in that situation. So can I get your comments? Because my concern, and we've been here, we've only had, this is our 4th day of witness testimony, and unfortunately it's scheduled to be our last day of witness testimony. We've seen a real outpouring of testimony from people in vulnerable communities about the impact that this has and the message it sends to those Canadians who are Canadians living with disabilities. So do you have any comment on that?
In 10 seconds, sir.
10 seconds.
Sorry.
Certainly a lot of people we treat for depression in geriatrics and in primary care have many other physical illnesses, which could be their excuse for requesting MAID.
Thank you.
Thank you very much, Mr. Moore. We'll now move on to the Liberal 5 minutes. I believe Mr. Virani and Mr. Sangha will be splitting their time. Mr. Virani, go ahead.
Thank you very much, and I'll be trying to be very, very quick here. A couple of just clarification points, Madam Chair, is that I think there's been a vernacular about the legislators here before the committee being in a position where we are taking away people's lives, as I think the way it was put. I think, in fact, what the legislation does and did in the past and continues to do is allow people to be empowered to make decisions about their own lives. So the autonomy and the taking is done by the individuals concerned, not by the legislators here. So that's the first point. Second point is that Madam Justice Chief McLaughlin, the former Chief Justice, Madam Beverly McLaughlin, was cited in terms of the testimony here, and I think it's important because it talked about equality rights and persons with disability. Madam Justice Chief McLaughlin was was part of the unanimous court in the Carter decision that talked about the Constitution requiring an ending of suffering in order to alleviate people's concerns and grant them the autonomy. So I think that's just important for the record to reflect that. I have a question now that I want to put to people, specifically Mr. Villeneuve and Mr. Chochinov. And I'll just say parenthetically that I appreciate, Mr. Chochinov, you underscoring the connection between gun control and the prevention of suicide. I believe all parties should be very conscious of that and the important need for gun control. But the question I put to you is that we've got nurses represented by Mr. Villeneuve and Dr. Chochinov. This was put to you earlier, and I'll put to both of you, if you could answer this idea that if pressure ever is deemed to have occurred, duress, influence, undue pressure, I would presume that that should be investigated, reported to authorities, and indeed prosecuted if it comes to that. So the question I have for both of you is simply that in the context of Mr. Villeneuve and you, Dr. Chochinov, do you have evidence of any such prosecutions occurring in this country with respect to nurses or with respect to doctors? So Mr. Villeneuve, to you first.
We do not have that evidence, Madam Chair. For nurses, conversation is a very sacred, sorry, can you hear me okay? Looks like it died. Is a very sacred one, and around critical care units, including organ donation and other very difficult conversations. I did not see pressure or coercion ever happening. In fact, much more the opposite. I'll turn it to our other speaker.
Mr. Chochinov?
I can't say that I know of evidence of overt coercion, but there's a form of covert coercion that we need to think about. People who are sick and nearing end of life or in pain or are living with encumbrances of physical illness begin to feel a burden to those around them. And so there are subtleties of coercion where they begin to feel that it becomes not their right, but their obligation to their families to alleviate them of the distress that they are living with. So overt coercion, no, but the subtleties of coercion, feeling the internal pressure that maybe this is something that I need to do, ought to do for the sake of my family who is suffering during the course of my approaching end of life, is something, a dynamic that I have seen played out.
Okay, and that's an important point, but the question I asked you is whether medical professionals, you're a psychiatrist in Manitoba, have any medical professionals been prosecuted for direct or indirect coercion?
Not to my knowledge, no.
Thank you. Over to Mr. Sangha. Thank you.
Thank you, Madam Chair.
Sangha. You have a minute and a half.
Oh, thank you, Madam Chair. And I'm glad at least CNA is coming for appearing into this case. CNA has recommended to include the provision addition of a review by some committee after 5 years. So why this is required, and what do you want to say on that?
Was that for me, Madam Chair?
Bellino?
Yes, it was, sir.
Yes, thank you very much. Our view as nurses is that this change in the criminal code is perhaps the most profound one in the history of our country. And we grew up, I'm old enough, once had a state where the only person that could end your life was the state.
Did we just lose?
And nobody else could do that. State can't do it. All right, can you hear me?
We're having some challenges with your audio and visual.
How about now?
That's you keep freezing on the screen. That's the issue.
Is it all right now, Madam Chair? I'll just say one more sentence.
Yes, please go ahead.
What I was trying to say is that we're now in the position where we have flipped that around, where the state cannot carry out capital punishment at the end of life, but in this very sacred space, a nurse and a doctor can enter into that with a patient. It's a profound change in our culture that I don't think we've begun to understand yet. And we believe it should be reviewed on a regular basis.
Thank you very much for that. We'll now go on for 2.5 minutes to Mr. Thériault. Mr. Thériault, go ahead for 2.5 minutes.
Merci beaucoup.
Thank you very much, Madam Chair. Dr. Boyle and Dr. Chochinov, you mentioned earlier when you were talking about the elimination of the 10-day reflection period that this is for patients whose death is imminent, as we know. You said that it could lead to people dying earlier. But we're hearing from witnesses that in practice, especially for witnesses who are in the terminal phase of their illness, for example, cancer, it's a long process. And the problem is that palliative care does not control all of the suffering and pain. There are adverse effects of palliative care as well, and patients can reach the point where they have no more control. So why would we not just look at the need to help people not suffer further? We don't want to focus on them dying earlier, but somebody who is dying or not, people need to have their rights respected.
Thank you, Ms. Cicero. I don't disagree.
Sorry, Ms. Boyle, if you can just move your microphone a little bit higher. Between your nose and your mouth is the perfect spot. Thank you.
We don't disagree that people need to have their rights respected. I think that's something that's very true. I think the challenge is that unless people have access to palliative care to help relieve, and we know that universal access to palliative care is not something that exists in Canada, and it is something that does need to be addressed. Regarding the reflection period, even for people with a reasonably foreseeable natural death, sometimes people do need time to address their suffering, have their symptoms addressed,
and they may change their mind. And it is contextual, as Dr. Chochinov has mentioned. And we do just need to make sure that we have legislation that addresses this.
Thank you very much. I will now move on to Mr. Garrison for 2.5 minutes. Go ahead, sir.
Thank you very much, Madam Chair. And I want to go back and assure him that I did get a notice to change of witnesses at 5:14 a.m. my time. So I do apologize once again. One more recommendation you had was dealing with the preliminary assessment clause. And I would like to give you time to talk about that because we have not heard about that in oral testimony from other witnesses.
Well, our view is, I'll just be very frank, we looked at it several times and we had trouble understanding what it meant. And I figure when a group of nurses with graduate degrees can't agree on what it seems to mean, that's probably a problem. And is it adding a layer? Is it adding another point of accountability? Could it slow things up? Is it meant to be the first conversation? So we believe it's fixable. We just think it's unclear the way it is now. And I'll leave it at that for others to speak.
Thank you very much for that. Often nurses, as you mentioned before, are the front lines of first contact when it comes to patients grappling with end of life or with irreversible declines. And I wonder if you could say, I think even more than you said before, about the difficult situation, the way things are currently configured puts nurses in as the first line of contact.
Well, just that you sort of feel like you have one hand behind your back if you can't raise certain issues. We talk to patients, for example, about why they refuse a cancer treatment that could cure them. Some people don't go along with the decisions we wish they would go along with. And I can assure you, I'm in dealing with a lot of nurses across the country, those of sound mind, I have not run into any who want to rush into any situation and introduce this. What we heard was from experts doing this, we felt we couldn't have the fulsome conversation. We couldn't even raise it. 86% of Canadians in the polls say they want to talk about it. They want the legislation there. We've talked about it for 30 years. The public is not informed on the details, but they're certainly ready to have these conversations. And we're saying, Nurse Betty with a master's degree, you can't talk about it. We have to fix that.
Thank you very much. So that concludes our rounds of questioning.
Point of order, Madam Chair.
Sorry, was that Mr. Lewis?
Yes, please.
Yes, go ahead, Mr. Lewis.
Thank you very much, Madam Chair. I appreciate the moment. A lot has really come to light today on a lot of different fronts. Fantastic witnesses, both in the first and the second. And obviously, I'm really happy that our colleague from the Green Party attended as well. I thought his comments were rather insightful. I believe that's the first time he's had an opportunity to come to this committee, and excuse me if I'm wrong. But I guess equally as impressive was Mr. Virani was the one that suggested that, very, very powerfully, he suggested that we give him a voice, and unanimously there it went. So, and as well, Madam Chair, even yourself, very eloquently earlier on, allowed for extra time for the first round of questioning. My point is this, Madam Chair, I believe us as a committee are running past an opportunity to have one more meeting. I think we would do a huge disrespect to our Indigenous disability community if we don't, as well as our vulnerable women. And I heard that point very loud and clear from Ms. Brayson. So, Madam Chair, I'd like to move that, notwithstanding the decision of the subcommittee for 4 meetings, I would move that we have one more meeting for 2 hours, please. And I would like a recorded vote on that, please. Thank you.
Okay, thank you, Mr. Lewis. Is there anybody else who'd like to speak to this at this time? Not seeing any hands raised. Mr. Clerk, if we can please administer a recorded vote on this.
Oui, d'accord. Mr.
Madame la
Cooper?
Présidente,
Madam Chair, could we please have a clearer explanation of the proposal? Could the clerk repeat the motion, please, so that we can hear exactly what we are voting on? What I understood of Mr. Lewis's motion, Mr. Thériault, is that notwithstanding the decision made by the steering committee to end our witness submissions today, that we have one more meeting. What I understood that was that the meeting would be held to discuss a particular issue. Is that the case or not? No, let's ask the chair to confirm with Mr. Lewis. Maybe I misunderstood.
Mr. Lewis, thank you for that. Mr. Lewis, is your motion specific to certain witnesses, or is this general to having one more meeting on this on this bill?
Thank you, Madam Chair. Specific for my motion, it's specifically to one more meeting. However, I did bring up those the Indigenous community with disabilities, women's disabilities community. I brought that up as examples of ones that I personally believe that we would have be doing our due diligence if we brought them forward purely as examples.
Thank you, Mr. Lewis. Mr. Thériault, does that apply for you?
Oui, Madame la Présidente.
Yes, Madam Chair. Thank you.
If I could just say, I find it's becoming somewhat repetitive that every meeting we're having entertaining motions to reverse decisions that were taken by a steering committee that has representation from all parties, including the official opposition. So I propose that we just proceed to a vote on this matter. Thank you.
Mr. Garrison, is that what you were going to raise as well?
I had tried to raise my hand before we went to the vote. I just say briefly, I believe that the answer is the larger review that we are obligated to do statutorily. Thank you.
Thank you, Mr. Garrison. With
Madame
that,
la Présidente,
Madam Chair, I just want to, before you end the meeting too quickly after the vote, that I have a proposal to make after the vote.
we will come to
Thank you.
the vote, Monsieur Thériault. Thank you. Go ahead, Mr. Clerk, if you can please record the vote.
OK, alors, Mr. Cooper?
In support of the motion.
Ms. Findlay?
I support the motion.
Monsieur Thériault?
je suis pour.
I support the motion.
Mr. Garrison? Are you there?
Against.
Mr. Kellaway?
Against.
Mr. Lewis?
I support the motion.
Mr. Maloney?
Against.
Mr. Moore?
Support.
Mr. Sanga?
I oppose the motion.
Mr. Virani?
Against.
Et dans la salle avec nous, Monsieur Zuberi.
Against the motion.
Oh, yeas pour 5-5, nays contre 6-6.
So the motion is defeated. Monsieur Thériault, before I come to you, I would just like to very quickly provide my ruling on the point of order raised by Mr. Virani at the meeting that was held on November 10th. Now this, Mr. Virani, at that time of our last meeting, for his point of order, was questioning the appropriateness of an intervention made by Mr. Cooper, where he referred to a position that he would have taken during the in-camera proceedings at our last subcommittee meeting. The House of Commons Procedure and Practice 3rd edition, page 1089 to 1090, tells us that, and I quote, divulging any part of the proceedings of an in-camera committee meeting has been ruled by the speaker to constitute a prima facie matter of privilege. So I would like to remind members about that important principle and call for their caution when they intervene at committee, not to directly, inadvertently, or obliquely refer to the nature and content of deliberations that have occurred during these in-camera meetings. Please note, however, that positive decisions emerging from such deliberations are considered to be public. With this clarified, I now consider this matter to be closed. Thank you. And right before I go to Monsieur Thériault, I would just remind members that the deadline for C7 amendments is no later than Friday, November 13th at 4 p.m. If you have any questions with respect to drafting, etc., please do get in touch with our legislative clerk. His email has been provided to you. And with that, lastly, then I'll go to Monsieur.
Point of order, Madam Chair.
I'm so sorry, Mr. Moore. I believe Monsieur Theriault has his before yours, so I'll go to Monsieur Theriault first. Go ahead, Monsieur Theriault.
Oui, merci.
Thank you, Madam Chair. I want to say that I had an issue to raise about these amendments. The meeting that we've had, like the other meetings, had a lot of substantial content, and I think it would be better to have a little more time before we introduce our amendments, because we need more time to think. So I would ask for the deadline to be Monday at 4 p.m. rather than Friday.
Thank you for that, Monsieur Theriault. I will go to Mr. Clerk. If you can, and I regret that we had not allowed our legislative clerk to come and speak to this matter earlier. But Mr. Clerk, if you can please clarify for us the reason why these timelines have been set and what restrictions does the legislative clerk have with respect to providing the full blanket of amendments to all members.
Absolument, Madame la Présidente. Écoutez.
Certainly, Madam Chair. People that are working on reviewing the amendments introduced by members need about 48 hours, that is business hours, to be able to decide whether they are acceptable and to get them together, to be able to give them out to members so that we can do clause by clause consideration. Unfortunately, if the committee decided to extend the deadline for amendments to the bill until Monday, the committee might have to delay clause by clause consideration. So if the majority of the members of the committee don't want to delay clause by clause, then we will have to stick with the date that was decided on, that is tomorrow at 4. If there are any amendments that come in on Monday morning, then we would have to deal with them quickly because we have to get them ready for the package to be considered by the committee in clause by clause on Tuesday. Thank you, Madam Chair.
Thank you for that, Mr. Clerk. And I will remind Monsieur Theriault that we had committed to this deadline based on decisions made in our steering committee. But if the member would like to propose a motion, if notwithstanding what the decision's already made, we can do that, or we can just do a show of thumbs if allowing for a yes or no. It's really up to you, Monsieur Theriault, if you'd like to put forward a motion.
Madam Chair, I thought I had presented a motion.
J'ai fait une motion.
That was my motion, to extend the deadline until Monday at 4 p.m. from Friday at 4 p.m. So that was my motion. The clerk opened the door to a type of compromise. Perhaps we could allow for amendments a little bit later than Friday at 4, but I do maintain my motion at this time. If my colleagues vote against it, then we will certainly take into account the clerk's comments.
Thank you very much. So we'll call the vote then in that case. Mr. Clerk, if you can please record the vote.
Madam Chair, before I call the members, I just want to highlight that if the committee does choose to put the deadline for Monday, November 16 at 4, we won't be able as a committee to examine the amendments for its meeting on Tuesday morning, the 17th. So just so that.
Thank you.
Yeah. Mr. Cooper?
In support of the motion.
Ms. Findlay?
I support the motion.
Monsieur Theriault?
Je suis pour.
Mr. Garrison?
Against.
Mr. Kellaway,
Against.
Mr. Lewis,
I support.
Mr. Maloney,
Against.
Mr. Moore,
I support the motion.
Mr. Sangha,
Against.
Mr. Virani,
Against.
and Mr. Zuberi.
Against the motion.
So, Madam Chair, yeas pour 5, 5, and nays contre 6, 6.
So the motion is defeated. Thank you, Monsieur Theriault. And now moving on to Mr. Moore, you had a point of order, sir.
Well, thank you, Madam Chair, for your ruling. Just a quick point is members have referred back to the decision of the steering committee, and that's not a problem. The decisions are public. But when members, like Mr. Virani has on several instances, whenever we talk about a way forward for our committee, references back to the steering committee meeting and says, well, there was members of the Conservative Party in that meeting, it is implying unanimity in the decisions, and implying unanimity in the decision is in fact disclosing what's happening at the steering committee. So if we could limit our discussion around steering committee to just the decisions, as you said in your decision, I think that will help everyone and make this go a lot smoother. Thank you, Madam Chair.
Thank you very much, Mr. Moore, and I stand by my ruling, which is a reminder to all members to keep in mind that divulging any parts of the proceedings of an in-camera committee meeting has been ruled by the Speaker to constitute a prima facie matter of privilege. I remind all members to be cautious in how we conduct ourselves to ensure that the principles that are established by the procedure and practice are well maintained in how we conduct our committees. Thank you very much.
Madam Chair, just while my integrity is being impugned by Mr. Moore, I'll actually take great umbrage with that comment. I guarded my words and used them very judiciously in this committee and in the previous committee. If there was a person that was reprimanded in this committee, it is actually Mr. Moore's colleague, Mr. Cooper, which you did in your ruling, which I found very edifying. Thank you very much, but I regret the implication. I'm not trying to do through the back door what cannot be done through the front door. Thank you, Mr. Moore, for your efforts and in vain in that regard.
Madam Chair?
Yes, Mr. Maloney.
If it provides any comfort to Mr. Moore, I never interpreted anything anybody said as there being unanimity, given who's on the planning committee.
Thank you for clarifying that, Mr. Maloney. And again, I remind members to be cautious in your wording so as to maintain the decorum and the principles and spirit of our House of Commons procedure and practice. As I see no more items on the agenda, I call this meeting adjourned. Thank you, everybody.
you.